Everybody, welcome. Thank you for joining us today. It's good to see everybody here. Thank you for joining us. There's just a reminder of the race on the 26th of October. That's next week, Thursday. Please make a mental note. Our next webinar, not seminar, webinar, I don't have a date yet, but that will be all about sectional title for the trustees. The aim will be to educate and equip trustees in managing the sectional title complexes. So that's the aim there. Then the first-time home buyers, the whole objective is to assist prospective buyers from the moment they decide to purchase a property to when the property is registered in their names, up to including opening of an account at the town council and paying their deposit. So obviously I will communicate with you, but that's the next two webinars that we have in mind. Contract Law 101, that will be in January 2023. We had that in the beginning of the year. There was a huge interest. We only take 10 at a time, so it's a small group. We had more than 100 people attending it over a period of 10 days. The whole idea with when you're at university, 101, 1 means your first year, and the 01 means it's the first semester. So it's absolutely the basics of contract law that we're discussing. That will be in January. Then next year, we, as per normal, we have our 5 seminars. The first one will be the 15th of February. All right. Today, we're going to discuss the state of the property practitioners' regulatory authority. I must say, for a Dutchman, that regulatory, to pronounce it, is quite hard. But we're getting there. Okay. John, our speakers here is Mrs. Deli Nkambule, an Advocate Debra Vial. We had all different pronunciations, Vial, Viali. Anyway, so Mrs. Nkambule, before I carry on, as you know, she's got this meeting at 10 o'clock. What I really appreciate of her, when I spoke to her, she said, please have a table for us with her management team. There at the back, we've got 2 or 3 people, and here the table in front. So afterwards, if there are more questions than what will be asked from you guys, then you can speak to her management team as well. That's on her request. I think that's very positive. Thank you for that. So Mrs. Nkambule is the acting CEO of the Property Practitioners Authority. Deli joined the PPRA in 2008 as a legal officer at the legal department. In 2013, she was promoted to legal manager, where she was responsible for investigations, dispute resolutions, and disciplinary hearings. And in 2020, she was appointed as the acting executive manager to head the compliance and enforcement unit, where she was responsible for overseeing a number of departments, such as the audit, claims, and Section 27, the legal department, including the registration department. In April this year, she was appointed as the acting CEO of the PPRA. Deli's 14 years work experience has been spent with the PPRA. Before joining PPRA, Deli worked in the banking sector compliance division. Deli holds a BA Law, LLB, and an MBA, and is an admitted attorney. Having an MBA is no joke, I can assure you that. She's obviously a highly intelligent woman. Advocate Debra Vial, qualifications, matric, BA, LLB. She's admitted advocate at the High Court. She's the Deputy Chair of the International J. Reuben Clark Law Society, South African chapter, board member of the South African branch of the International Birthright Organization, member of the PPRA Pension Fund Board of Trustees, current employment, acting executive claims, compliance and enforcement, 1st of April from this year, claims and applications manager, EAB, October 2014 to current. I was under the impression you're the legal officer, officer, not okay. But anyway, you will help us with that. All right. Thank you again, Mrs. Nkambule, Advocate Dial. We really appreciate it. People, we are going to record it. It's the first time that we're recording a seminar. So if you want it, you can ask for it afterwards. No guarantee in terms of the quality. It will be our first time doing that. Thank you for joining. And then Mrs. Nkambule, thank you. Thank you.
Good morning. Morning, everyone. It's a pleasure to be here and see some of the people that we work for, the people that we're supposed to serve, and I am grateful for offering us this opportunity to come and meet our important stakeholders. This is our first time in Benoni, and it's our first time meeting this group of people, especially under the PPRA. So I am here with my team, Debra Vial. At the back, I have also two of my team members, and what we have decided to do at the back, we know that as a regulator, there are places in which we do not do well, especially in responding to complaints or one of the queries that we have is registration. So we've got our help desk today there. We will try and also register and deal with your queries today. So we really appreciate the platform, and we really appreciate what you are doing for us by involving us as the PPRA. So I just have a slide presentation. I want to just go through our presentation here, but I think it's something that you know, and I want to go, So we all know that the legislation that we are now governed by came into effect in 2019. It was signed in law in 2019, but however, it only came into effect in 1st of February 2022, and it was quite a long time because although the act was in place, we had to deal with the regulations. We all know that the regulations speak to how then do we implement the legislation. And because there was this consultative process where we were now going to regulate not only estate agents, but a number of role players within the property sector, the consultative process took a long time. I think if you look at the fact that we are now regulating 12 new role players, if you can just move on to the next slide. These are the 12 new role players that we are now regulating. And each and every one of these role players have their different requirements because they are different industries. We could not then, as the PPRA or as the EAB, box all of these people into the same requirements as estate agents. And therefore, the consultative process was very important for us to understand how then are we going to regulate these people that we are now bringing on board. So, we've got a big task ahead of us. And I think the biggest task that we have as the PPRA is trying to set up the new educational requirements. Currently, we do have the NQF4 and NQF5. But these have to be changed. They have to be changed in the sense that for a very long time, we've had how the industry has been unhappy about the bulkness of these educational requirements. And what the legislation has done is that it has compelled us as the PPRA to then consult with the industry bodies so that we come up with specific educational requirements, course material, that is applicable to each and every industry. So, for example, during our consultations, we met with the vocation, I think it's VOESA, and they were saying to us their members are not going to be able to do NQF4, they want to do NQF5. It was a shock for us because what we are trying to do is that we have an industry that is qualified. But however, that said, we cannot overlook the fact that they are saying within their industry, their people have your standard 8. We need to now work around that to ensure that how do we then assist them to an extent that they also from your standard 8 go to as higher as having your NQF4 and NQF5. But all in all, what I just wanted to bring about is that we are busy with the consultations in setting up the educational requirements. So from myself and my team, we will be answering some of the questions that have been posed by us. But just to also go through the Act, we've got a transformation provision in our legislation. So what the legislation has now mandated us to do is to try and bring in more Black people in the industry. And in order to enable us to do this, the legislation has then created what we call a transformation fund. And within the transformation fund, we've got money that we will use to drive transformation projects or transformation initiatives. We'll be able to explain those transformation initiatives as we go through the questions that have been posed to us. And then I Under the EAAB, we had our inspection powers removed. We had a huge case that took quite a long time, and we were supposed to amend the legislation, but because we knew that we are having a legislation that is coming, we decided to pause that and then deal with the inspection powers in our act. So we now have inspection powers, and in terms of our inspection powers, our inspectors can issue fines using compliance notices. And then also, in terms of your application process, you know that as the PPRA, we register two types of, we register an individual and we register a firm. So for each and every registration that we do, we require you to have an application form. We require you to have certain documents. For example, if it's a firm, you must have your CIPC documents, your BEE certificate, your tax compliance. And if it's an individual, we want your letter of employment, we want a certified copy of your ID, but we'll also be able to get through that when we answer the questions. And then obviously what we have done is that as an entity, we are now issuing a 3-year FFC. We've moved from issuing the yearly FFC. And then the Act has also retained the conduct of property practitioners. So we've got a code of conduct, a detailed code of conduct that even speaks to undesirable conduct. It prohibits estate agents or property practitioners, from entering into conduct that is unprohibited. And we know of those unprohibited conducts where people are forced to use services of certain services of service providers, and that is now prohibited. Also, we've got exemptions. It's a new provision. It allows you to request for an exemption from the application of the Act, from any provisions of the application of the Act. There is a process that you will have to follow, but we'll explain that, and then we will grant you the relevant exemptions. So in terms of your audit, previously you knew that when you did not submit your audit, your firm was blocked and you could not get an FFC. That has been done away with. What we are going to do is that we are going to impose fine for every month in which you have not submitted your audit, but you will continue to get your FFC. I think that the industry will welcome, because it created problems for us as the PPRA, having to fight with our stakeholders when they can't get their FFCs because their auditor is not finished auditing their audits. So yeah. And then we also have a clause where if you are not, or you do not want to operate or have a trust account, you can then be exempted in terms of the Act. So that was also one of the issues that our stakeholders were very worried about, to say, you know, I have this trust account, I pay the fees in respect of this trust account, but I don't use it. All the money goes to an attorney. So we now have a legislative provision that then exempts you from operating a trust account. I've mentioned that our FFCs are for 3 years. Our fees and costs are then prescribed by the law. Previously, we had to, obviously, every year we had to have them gazetted, but now they are then prescribed by law. And what the law has then done to allow us to increase them is to give us a clause that then allows them to increase them based on CPI. So I think that's all from me. I'm rushing for us to answer the questions, but we will take more questions once we have dealt with those. Thank you so much, and thank you to you as well.
When I invited these two ladies, I've got a few questions from certain role players in the industry, and I asked, and I put it in, it's 2 pages of questions that I put to these ladies, and Debra's going to try and answer some of them. We just need to keep an eye on the times, because Ms. Nkambule has to be ready for the meeting at 10 o'clock. But thank you.
Hi. Good morning, everybody. Am I speaking into this thing correctly? Thank you. Lovely to be with you, and thank you for the opportunity to speak to you and perhaps just elucidate a few of the more difficult navigatory issues that we have with the new legislation. Okay, so was the PPRA implemented too early or too soon? And so was the result that logistically the administration was or is not ready for implementation? Right, our acting CEO did mention the fact that the Act was passed already in 2019, but it didn't come into effect until February the 1st of this year. Unfortunately, the regulations in their final form were only published in January, the same time as at which the Act was brought into existence. So we had very little notice of what was actually in the regulations. And although we had had some input, unfortunately, we weren't favored with the final drafts until right at the end. The result of that was that issues such as education, which are absolutely essential for us to prepare to register property practitioners, were not known. We didn't know at that stage what Regulation 33 was going to say, what was going to be required. We also didn't know how exemptions in Section 4 were going to be implemented by the regulations, what the requirements were going to be for those kinds of processes. And that was essential for us to develop our systems, that knowledge. We couldn't develop a system which did not take into account how we would exempt certain persons, how the process would work, what we were allowed to do and what we were not allowed to do. So we ended up on the 1st of February with a system which was unfortunately not fully prepared for us to implement it. And so that's the huge problem that we've had in implementing the Act in regulating all 12 of those various property practitioner industries. The result has been that we have had to find a way to assist our stakeholders. And what we have done is estate agents continue to be registered as our system allows, with the same provisions as have always applied. But as far as non-estate agents, we have allowed and we have pre-populated the exemption form, which you find in the regulation. It's Form E1, for non-estate agents to say, we will ask you to apply for an exemption from Section 47 and 48 of the Act, which are the two provisions which require you to have a Fidelity Fund certificate in order to operate. So you can continue to operate and obtain commission, etc., if you are a non-estate agent, until such time as we are in a position to register you and issue you with a Fidelity Fund certificate. And we have at that stage established what the registration requirements are. So that's basically the situation that we find ourselves in, and that's what we've been doing in order to try and address those issues. Deli, are you going to deal with training?
One of the questions that we were asked is, are you working with the services sitter when addressing the formal qualification requirements and accreditation as accredited until the end of June 2024? And I think they said that it is indeed worrying that the impression has been created that the property practitioners do not need to obtain qualifications anymore. We can confirm that we are busy working with SITA. We cannot have qualifications that are not accredited by SITA. In fact, some of the new people that will be regulating, for example, your auctioneers, they have come to us and told us that their qualifications are SITA accredited. And what we are then doing as the PPRA, we are not going to reinvent the wheel. We are going to work with them in order to take what they now have and put it as the new educational requirements for auctioneers. In fact, not only for auctioneers, for each and every industry. I mean, we've got industry that have been existing for long. Last week, we were in Cape Town with the managing agents. They are also at an advanced stage in relation to their qualifications. We are also working with them, and we will use their qualification as the requirements for you to be accepted as a managing agent under the PPRA. So we're not going to reinvent the wheel. In fact, we've got a legislation we've got a provision in the legislation which compels us to communicate or to consult with these industries so that we can get to the bottom of this educational requirements. So I can confirm that we are working with the SITA. And then the question that followed is, when are the new training requirements going to be published? We are busy at work consulting. We are hoping that by December we'll have some sort of a draft. And in terms of finalization, we are looking at somewhere around March, and then we will be able to implement. So that's the time period within which we have set for ourselves, and hopefully we will be able to keep to that. And then it says, when are CPD training videos going to be released for 2022? Why must the agent pay for this if there is no material? Currently, the CPD is, I don't know if anyone has been able to access it. Yes, thank you. So the CPDs are out, and we unfortunately do apologize for someone who is not aware that they are out. But if you are having technical problems in terms of accessing the e-learning, then we will be able to assist you at the help desk. But those videos are already out. And then the next question is, what is the long-term vision of the BEE certification? As anybody can work in our industry, it's commission-based. Furthermore, what would the incentive be for an owner to be BEE compliant? Okay, this is a very thorny issue. Remember that BEE, we are not the regulator of BEE compliance. All what the legislation has done is to then compel us to say, if you want to be registered, you must have a BEE certificate. And please take note, it doesn't matter what level of, at what level you are, then the compliance in terms of BEE is not the issue here. What you are supposed to do is to submit a BEE certificate, even if it's non-compliant. So we are not enforcing BEE compliance. We are enforcing the submission of a BEE certificate. Whether it's compliant or not, for us, it's irrelevant. You just need to submit it. And I think this is the basis for the legislation to then, as we transform the industry. So what they are going to do, how we understand it, because we did question what was the need for it, is to say some provisions, when you introduce them in a legislation, you must phase them in. So we're requiring, what will happen is that once we've received all the BEE certificates, we'll then, through the property charter, do a report or an analysis as to whether property practitioners are compliant with the BEE requirements. And then from there, the legislator will then go back and see what else they need to then tell us as the PPRA to do in relation to BEE. Maybe when they come back again, that's where we will then enforce compliance with BEE, to say everyone that has a firm must ensure that they are compliant with BEE. So for now, that's not the case. You just need to submit your certificate. And if you are exempted from submitting, you submit your affidavit, because there is a threshold. There are firms that are not supposed to be submitting their BEE certificates based on the threshold. You submit the affidavit. I just want to go through the transformation initiatives, and then the Act is all about transformation. But what transformation is planned other than forcing agencies to be BEE compliant? No. Remember, we said that the BEE certificate, we're not looking at your compliance. So that's not the transformation for us. For us, transformation, we have certain programs. One of the programs, or some of the programs that we have what we call a youth brigade program, where we place interns or learners with host employers, and we pay them a stipend. They are placed there in order to get training, and while they do their qualification and educational requirements, and then we, as the PPRA, in collaboration with SITA, we pay the stipend. So all we are asking from estate agencies or firms or principals is to just give them an opportunity to work, and we will pay their salaries. And then also we've got principalization programs where we help people that are within your full status estate agent to acquire your principal status. So what we do in that respect is we will be able to pay through the transformation fund, we'll be able to pay for your exams, your PDE exams, and we'll be able also to pay for your course material. So that's the transformation initiatives we have. Also, what we are also going to be doing as the PPRA is that we, in terms of the MTSF strategic plan that is part of government, we need to ensure that 40% of Black women are assisted in setting up their companies. So we will fund those Black women. We will assist them to set up companies. And then through the transformation fund, we will get money from there and assist those Black women in order to transform. So those are the transformation initiatives that we are carrying, not the BEE certificate compliance. And then I think I'll hand over to Debra so that she can take over the next set of questions. Thank you.
Yes, thank you. Thank you to CEO for that. And I think you can see that we're serious about transformation. And the nice thing about the new Act is that it has an entire chapter on what our mandate is, as well as giving us some teeth in being able to actually do something. The old 1976 Act, of course, didn't give us any mandate to do anything of any value, of any note, despite attempts which we did make. And you'll find now that our hands are no longer tied, and we have various opportunities which we intend to take advantage of. All right, the next question is about interns, and it relates to the question of whether the logbook is still required, and it refers to candidate agents. Now, I'm not sure if the question intended to refer to candidate practitioners or if it was limited to estate agents. But the answer to that certainly is that for the moment, the logbook is required for estate agents, as it always has been. Nothing has changed in that regard. As Deli mentioned, the new industry participants, or those that we regulate, which is the non-estate agents, we are in process of consulting with each of the industry bodies to see how they would like us to implement Section 33 and what its requirements are. You will remember that Regulation 33 requires us to have a period of 6 months candidacy for property practitioners. It also requires us to have a PDE exam for all property practitioners. And we are required to consult with industry and to come up with material as well as the examination, as well as the process, which suits the industry and which is industry specific. So that's what we're in the process of doing right now. But as far as estate agents, it's business as usual. Your NQF4 and PDE exams remain in force, and we are conducting them currently. The next question about interns is the progress regarding proposed amendments to internships or logbooks, and the status for interns registering after February. As I've said, nothing's changed. I think that was dealt with in the first section. State agent candidates register as they always have done. They get their 3-year FFC as they do in terms of the new provisions of the Act, and they're required to continue and apply Regulation 2008, which we used previously under the old Act. When it comes to that implementation, and I think that talks to something that many of you had a problem with and many of you were not sure about, and that was what happens now to the old 2008 regulation. Does it fall away? Does it mean nobody needs any kind of qualifications to be an estate agent under the new Act? And we actually went out and got a legal opinion on that. The legal opinion was that until such time as the new regulations and the requirements as part of the consultation process have been finalized, those 2008 regulations for estate agents remain in force. Obviously, they don't apply to non-estate agents. They were drafted and regulated estate agents only, and they continue to do so. So we will continue to implement that regulation in the interim until we have a new process and new standards, which we have developed specifically for each industry. Right, now I need glasses again. All right, the last part of the intern question was, can the PPRA withhold issuing an FFC for agents who are still interns? In brackets, according to the Act, they cannot, but we would like clarification. Okay, the question was not entirely clear to me. When they talked about agents who are still interns, I'm not sure if this was a reference to serial interns. In other words, interns who took longer than 2 years to comply with the requirements of the 2008 regulations. And we have been for the last, I think, 6 years trying to get serial interns to comply. We've had a lot of complaints from the industry about the fact that interns are year after year given their Fidelity Fund certificates and are able to continue to operate even though they hadn't complied with the 2008 regulations, which gave them 2 years to do so. Now, under the new Act, we have the Section 50 provision, and Section 50B talks particularly to those who have not complied with the educational requirements for their industry, and the fact that they are prohibited from receiving a Fidelity Fund certificate if they have not complied with those requirements. So we have the empowering provision in Section 50B of the Act relating to the withholding of FFCs for those who are non-compliant in relation to educational qualifications. Obviously, for the moment, that will apply only to estate agents until such time as we know what is required for the rest of the industries. So at the moment, we have certain deadlines in place, and it was June of next year for serial interns to obtain the necessary qualifications so that they can then progress to the full status agent status in our records, and also they can continue to operate on that basis. Right. There were then some general questions which we were asked to address. The first related to the trust account. And I think it's important for us to remember that there are 2 sections in the Act which relate to exemptions. One is Section 4, which relates to general exemptions from any provision of the Act. And those exemptions can be applied for by way of the Form E1, which is in the regulations. You will find it there. We can also make it available to you should you require it. And then there's Section 23, which allows the minister, in relation to the regulations, to specifically exempt any parties from holding a trust account. Now, in terms of Section 23, the minister has passed Regulation 2. If you look at Regulation 2, you will see that it is devoted entirely to the exemption requirements for a property practitioner not to have to hold a trust account. You should be aware that in terms of the Act, there is still a blanket requirement that all property practitioners must have a trust account. So if you want to be exempted from one, Regulation 2 is what is required to do that. And you will see that the question refers to the use of Form E1. And in fact, that's incorrect. In most instances where you qualify for an exemption from a trust account, you will not use Form E1 at all. You will use the affidavit that is specified in the regulations for use for the exemption from a trust account to be invoked. So you don't have to go through the entire process. All you have to do is submit an affidavit in the format set out in the regulations, confirming that, first of all, you don't have a trust account. Secondly, you don't receive trust monies. Thirdly, you undertake not to receive trust monies in the future. If you did have a trust account, you have closed it. It has been wound up and it has been deregistered with us. And that you also undertake that should you at any stage have to receive trust monies, that you will give us 60 days notice of that. You will open a trust account and register it with us in terms of Section 54(1), and that you will then no longer be exempt from the opening or the holding of a trust account. And that's what the affidavit has to say. So as soon as you depose to an affidavit which contains those kinds of undertakings and assurances, you submit that to our audit department, and our audit department will, in the record and on your profile, make a note of the fact that you are exempted from holding a trust account. I think that explains, I hope that explains the trust account issue a little more. The next question related to inspections and how we deal with inspections. Deli, would you like to do it, or shall I? Shall I go on? Thank you. All right. As Deli indicated, we now have inspection powers, and something we have which we didn't have before was the right for our inspectors to issue fine notices. Believe it or not, that's actually a good thing for you. And the reason I say that is because before you had to get a summons, you had to go before a disciplinary committee, it used to take a long time, you couldn't get a fidelity fund certificate in the interim, and you could get a fine of anything up to 25,000 Rand, or you could get a reprimand, or you could have your fidelity fund certificate withdrawn. Now you don't have to go through that process. Now it's a case of, here's a notice, you haven't done X, Y, Z, which you should have done. Please rectify it by Y date, and please pay the following fine. And the fines are set out in the table in the regulations. So you know more or less what you're in for from the beginning. Okay, so our inspectors will be able to do that. And the question that is asked is, how often will estate agents be inspected? We used to do inspections on a rotation basis back in the days of the Rinderpest, when we were still able to do inspections. And what we did was we would rotate so that everybody got inspected perhaps every 3 years. As you know, we are, in terms of FIC, we are required as a regulator to ensure that FIC is complied with, and we are an oversight body in respect of FIC for those in our industry. Now, FIC have changed their approach in line with international requirements, which is that we now have to adopt, on the instructions of FIC, a risk-based approach in respect of inspections. So now we have to inspect high-risk estate agents that are in high-risk areas, estate agents that are in very busy areas, that deal with large amounts of money, that are likely to be targeted by money launderers, and the like. So that's basically a risk-based approach. You might, as a result, be inspected 3 years in a row. You might never be inspected, because we have to comply with the outlines set out by FIC in relation to that. Okay. All right, perhaps Deli would like to speak to C, which relates to the administrative internal systems which we are developing, the problems that we're having, and how we're going to deal with that.
So in terms of our system is, as explained to us by our developer, it's very static. It does not allow many rules within it. And when we then tried to overhaul it or introduce new requirements so that we could be able to accommodate the new property practitioners, it proved difficult. The first thing that we had to do was to upgrade the subsystem itself to the latest version, which we successfully did. And then once we had done that, now the developer is back working and looking at the rules that will be applicable to each and every property practitioner that will be registered. However, that's not the only thing that we have to do. Our infrastructure is also old. It dates back to 10 years. Our servers are quite very old. And we have had to then obviously procure new servers. The building has had, we are in Sandton, by the way, but yeah. I'm not going to say much. Our building is very old. I think when we bought it, there were certain issues with the building. So in terms of the infrastructure that is there, it's quite very, very old. So we are then updating even the infrastructure in order to also ensure that we are up and running. We have then obviously gone and got a service provider that has installed UPS. We have batteries now that are backed up so that when there's load shedding, we don't suffer and we're able to service the industry. So those are the type of infrastructure upgrades that we had to do so that we are efficient. And it has cost us quite a lot, but I think for us to be able to efficiently service the industry, we will have to do an overhaul of our systems and infrastructure. And currently some of the processes, because we are undertaking this very massive project, we are going to be handling them manual. For example, the new property practitioners, we are granting them pre-populated exemption forms, and that's a manual process. But what we are happy about is that we now have a database of all these new property practitioners. Once our system is up and running, all we need to do is then to import the database onto the system, and then we give them Fidelity Fund certificate. So that is where we are in relation to upgrading our system. Then any question? Okay, then the question is, why was the over 60 age-based exemption taken away? Yeah. Okay. It's not supported by the current legislation, but here's the good thing about this current legislation. It does provide provisions for even over 60s to be exempted. So we've got a provision that is called Section 4, which allows for exemptions. So if you are over 60, what you can do is you can download the E1 form, request for an exemption from the educational requirement based on your age, and then we will consider it. Obviously, we will request for a POE and evidence to show that you have been in the industry, that you've got experience in the industry. We will also be looking at the history in respect to your Fidelity Fund, how have you been renewing, whether you've got Fidelity Funds for certain period of time. So we're not just going to accept everyone that says they're over 60 and want to be in the industry. No, we will definitely make sure that we give exemptions to people that are over 60 that have been in the industry. So you can't retire from ABSA and then want to come and join the industry. No, that's not how it's going to work. You must go back and do the same exam. For example, I, as an attorney, if I wanted to be a quantity surveyor now, I'll go back and read. They're not going to just allow me. So we shouldn't allow this industry to be infiltrated by people who have just retired and now want to come into the space because they have nothing to do. I mean, some of us have been in this profession. I've met young people who have been in this profession. When we were doing the NAMA, a lady I met said she was 75 and she has been in the industry for 45 years. So you tell me that that person must compete with a person who has been working for ABSA for the past 30 years and then wants to come and join the industry, and it's a free ride industry where you just come in and you request for an exemption and then you can qualify. No, shouldn't be like that. We also want people to take this industry serious. If you are going to choose this industry as your path, then you better start now. Don't wait for retirement. In fact, retirement means you must go and rest. Allow the people that are in the industry to continue making money. I mean, for us as the PPRA, we need to ensure that it's a commission-based industry. And it's not a salary. If you are working, sorry, I'm busy using ABSA. Okay, let me use PPRA. If you are working for PPRA, you get a salary every month. But for you guys, it's a commission-based. And when that commission or when that sale goes through, you know that that has been your hard work. So it should remain that. It shouldn't be an easy ride. So from me, over 60s, it's still there, but it's going to be very difficult.
Right, thank you. Thank you, Deli. The next question which I need to discuss with you is, if a person acts as a principal for more than one agency, the renewal fee for the 3-year FFC must be paid for each and every agency per principal. Is this the way it will be done going forward also? Well, the answer simply to that is no. And the reason for that is because we have a provision in the regulations, particularly Regulation 41.22, which says that if you are operating in a particular industry within the property sector, in other words, let's take the estate agency industry, you will apply for, as an individual, a Fidelity Fund certificate, and that Fidelity Fund certificate will be able to allow you to operate within that industry, no matter who you work for, no matter what you're doing, as long as you are operating within that particular industry. If you're operating as an auctioneer as well, then you will need to get a 3-year FFC as an auctioneer. If you are only operating as an estate agent and during the period of your 3 years you move from one firm to another, It will not be necessary for you to pay for and receive a new Fidelity Fund certificate. Okay? Your Fidelity Fund certificate remains in force. This is the reason why, and it's another question further down on the list, there is not a provision in the Fidelity Fund certificate template in the registration implements in relation to this matter, and they specifically requested this because of the costs involved in changing from one employer to another. And so the result of it is, if you have a Fidelity Fund certificate which says you work for Remax and you move and work for Pam Golding, your Fidelity Fund certificate is now incorrect. Okay? And in terms, there are regulations which relate to the use of a Fidelity Fund certificate that is incorrect. Okay? So you can get into trouble for that. So what has to happen is we have to give you a Fidelity Fund certificate that doesn't state who you work for. It simply says, it does state what industry you are involved in, and that is in the template. Okay? So we've had a lot of pushback from a lot of estate agents themselves on this, saying, but I want people to know who I work for. And for us, it makes sense for people to know who you work for. But that is the state of affairs, that is the state of the legislation, and it was at the instance of some of the estate agency bodies that this actually came into being. So that's the position currently. All right. Next question. Statistically speaking, an agent remains an agent for approximately 3 years. What plans do the PPRA have in place to ensure the contingency of a career in real estate for new and upcoming property practitioners? I'm assuming that contingency might mean continuation of a career. In other words, the retention of new and up-and-coming estate agents or property practitioners, because that would make more sense. And obviously that relates to our BEE activities, which our acting CEO discussed with you. Part of that is incubation in our research center, which has now come into being as a result of the new Act and regulations. It's part of the transformation process. It's also part of the fund, the transformation fund's mandate to assist agents and property practitioners to come into the industry and to be able to cope with the ups and downs of the industry. So it's part of that BEE transformation mandate that we have to try and ensure that especially those young, up-and-coming, previously disadvantaged estate agents and property practitioners that come into the industry are able to maintain it and are able to weather the storms that will come their way. The next question relates to trust monies, or rather trust accounts, and it refers to the fact that financial institutions are not ready with legislative changes from the EAB to the PPRA for opening of trust accounts. I'm quite pleased to see that we weren't the only ones. But certainly, in terms of the old Act, you will remember, you needed to register a trust account, and it had to be designated as a Section 32(1) trust account in terms of Act 112 of 1976. The same thing applies under the new Act, except it's now Section 54(1). We were, right from the beginning, in discussion with many of the banks, in fact, all of them. And our audit manager had long discussions with them on the implications of this requirement, whether they could accommodate it, when they would be able to accommodate it. And we actually came to agreements with many of them right in the beginning to say that we will continue to accept their letters stating that Section 32(1) trust accounts have been registered, but with the proviso that as soon as their systems are able to do so, and they were busy developing them, they themselves would automatically change that trust account to a Section 54(1) trust account. Okay, so that was very kind of them. They were going to make that their business to do that, but please remember that it is your responsibility as a property practitioner to ensure that that happens. Okay, so do check with your bank, do check when you look at your statement and see if that has happened yet. And if not, ask your bank to change it to a 54(1) trust account. All right, but we certainly have been taking and registering people using that provision from the old Act, with a view to ensuring that each of them will be changed as a matter of urgency as soon as the banks are able to do it. And many of the banks are currently able to do it. So we've had many of them changed already to the new provision of the Act. Okay, I've dealt with the question on why the FFC doesn't reflect the agency's name. The next question, what is the PPA going to do about the fines that accumulated against agents that did not deregister? In other words, agents now wanting to re-register under the Act. Okay. Well, the Act and the regulations specify that. Under the old Act, there was a provision in the regulation on registration and fidelity fund certificates that you had to renew your fidelity fund certificate for the following year by the end of October. If you had not advised us in writing prior to the end of October that you would no longer be operating. Now, what happened was many agents decided sometime during the year, I don't want to do this anymore. I'm going to do something else, or I'm taking a few years off, or I'm going on a holiday overseas for a year, or whatever it is. And they simply left without advising us. And there was a provision particularly which set out a fine which said that if you did not renew as you were required to do, having not told us that you're deregistering, you would be paying a specific amount monthly as a renewal penalty. And that's how so many people accumulated such a huge debt. In order to assist to accommodate those people, we did obtain permission from the previous, now suspended CEO for us to have an acknowledgement of debt signed by those persons, but the requirement was that they had to be paid within 6 months. So that was quite difficult. Unfortunately, the same thing applies under the new Act. The same provision is there that if you fail to renew by the end of October, you attract penalties. And unfortunately, the regulations in this regard are somewhat contradictory, because we have an amount in the fine table for failing to renew on time, and we also have an amount elsewhere under the registration requirements, which is a different amount for failing to renew promptly. So our board will no doubt decide which of the fines they're going to impose, and we're waiting to hear which one it's going to be. But that provision still remains. So if you leave the industry, it's essential that you deregister, that you tell us that you are leaving, you are no longer operating, that you do that before the end of October as required by the regulations, and then you will not attract any kind of penalties of any nature. Okay. All right, there was a question about the CPD payment for 2020, which was waived due to COVID. But I understand that some people are saying that their agent's profile still reflects that that payment is due. I apologize for that if that's the case. It shouldn't be. We have, in I thought all instances, reallocated any payment that was received for 2020 to 2021, and our system is programmed not to require a payment for 2020. So if you are having that problem, please would you speak to Naledi or Carol at the back, and we'll have to get our IT department to see what glitch is making your life difficult and why it is that is still showing up, but it should not be. Right, next one. If an agent has been selling and renting properties without holding a valid fidelity fund certificate, is it true that he still has time to rectify his position and become compliant without any consequences to his previous unlicensed activities? All right, well, the regulations say that if you were operating illegally and you didn't have a fidelity fund certificate, we will not prosecute you for that, or we will not discipline you for that, as long as you come to us within 6 months of the Act coming into being and register and obtain a fidelity fund certificate within 12 months. So the 6 months has basically come and gone. If you did register, but you did not get your FFC yet, your 12 months has not come and gone, and you can still get your FFC, as long as your registration was in the 6-month period. If you are outside, if you were operating illegally previously and you want to come back, there is the chance that the PPRA may, in respect of the requirements of the Act, charge you for operating without a Fidelity Fund certificate in the past, unless the waiver has applied to you and you have complied with the requirements of that provision. And then finally, is the PPRA portal up to date with agents who are registered and hold a valid FFC? In other words, if one types in an agent or agency's name and the system says not found, can one take it at face value that the agent is not a registered practitioner? Right. In that regard, there are a couple of things I need to mention. First of all, our system, like most computers, they tell me stupid. They only identify exactly what you put in with what they have in their database. So if you know somebody as Joe Soap, and his name is actually Joseph Edward something else, and you put in Joe Soap, it's going to tell you, sorry, Joe Soap's not registered. All right? Because it doesn't know Joe Soap. It knows Joseph Edward, etc., etc. Right. Similarly, if you're going to put in someone's ID number, you will be aware that some time ago ID numbers changed. The last 3 digits changed. Some of us were 002 and it changed to 085. Some of us were 007, it changed to 082 or whatever it was. Now, estate agents who previously were registered with us have always had the ability on the portal to update that and to change their information. Many have forgotten that their ID number has changed. And so some of them, we still have their old ID number. And if you or someone out there puts in the new ID number, our system is going to tell you, sorry, no such person. All right? So do be aware of that and check that we have the correct ID number. The same thing happens with firms. We have many firms who are registered as Company 12345 Pty Limited, trading as Remax Coastal. Okay? Now, if you put in Remax Coastal, it will either tell you it doesn't have a Remax Coastal or it tell you it has 5 of them. Okay, because there's Remax Coastal something, there's Remax Coastal different branches, etc., etc. Okay, but you will need to put in the registered name of that entity for us to be 100% sure that it's going to give you an accurate result. Okay, so do be aware of that. We are up to date. Our system is completely up to date with everybody who has registered and has an FFC. Okay, the portal, unfortunately, is less than reliable, and I don't need to tell you that. It's as much of a thorn in our flesh as it is in yours, and we are constantly having to revisit it, get someone in to find out why it's now crashed, what's happened to it, and it makes it very difficult. So we are working on that, as Deli said. It's costing us a huge amount of money, which we're spending on servers and on all sorts of things, and upgrading the SAP system we had to a better SAP system, and having storage in the cloud instead of where we had it, and so it goes on. All right. So I'm afraid we are going to have the odd glitch or sometimes when the portal is down. Okay. But please do contact our call center and ask for emails. They don't have the ability to transfer you to somebody back in the back office. Unfortunately, the system doesn't allow that. And looking at our call center and upgrading it is another thing that we have to do, and we're hoping to be able to do soon. But they can give you the emails of the managers and the administrators who are working with whatever it is that you have a problem with, and they can get back to you. Okay, I believe that was the last of the questions. I think I've dealt with all of them. Thank you very much.
Thank you, Debbie. People were always trying to keep this to an hour. I think let's make it fair. There's Carol and the lady at the back. They will assist you. And then Advocate Debra will be here in front. I think let's call it a day. Help yourself with some eats and drinks, and then go and ask your questions, whatever you want to. Thank you for joining us today.